Page number 27. Page number 27, paragraph number 60. 60. Paragraph. This is a copy of the paragraph. Number 2. What happens is granted expert. Now, after the probate has been granted expert, optional file is granted on the basis that there was no further evidence from our side. Now, after the expert has been granted, within time we find an application online. Entire client and the family USA and he's undergoing cancer treatment. I have evidence to that. So order time to 30 weeks at the present moment, and it stays the order to taking. And here's how the order time would look. So that they don't take advantage of the product and sell off the product. This is the short version.
Lord, sorry, my lord, I'm appearing on VC. Lord, I'm.
No, my lord, we are
my lord, it's a question of my lord. I'm so sorry, my lord. I'm on video conference. My lord, first of all, my lord, they have asked for recalling of an order. My lord, really, my lord, order which my lord disposed of, my lord, a probate application by granting probate. My lord, if it's for recalling of an order, my lord, they will have to go, my lord, before the learned judge, my lord, who passed that order. That's, my lord, my first, my lord, question, my lord, whether. Yes, my lord, they have to. Second of all, my lord, under probate, my lord knows. My lord, second, my lord, under in probate, my lord knows if a probate is granted, then, my lord, under section 263 of the Succession Act, he has to make out those grounds before, my lord, he can ask, my lord, for recalling of an order of probate. And, my lord, thirdly, my lord, he had participated in proceedings up to a certain date. Thereafter, my lord, all of a sudden, my lord, he did not participate. The learned, my lord, judge has considered, my lord, all the evidence which was produced and then, my lord, granted probate. So there's no question of, my lord, coming and saying that just because I did not appear, please stay the entire order which has been passed. Fourthly, my lord, we will show the conduct of, my lord, this particular litigant. She is, my lord, a very, my lord, disgruntled daughter of, my lord, the testator. All the other heirs, my lord, have given consent so far as the probate is concerned. She is one daughter, my lord, who's been opposing it. And, my lord, who has this habit of making, my lord, applications after orders have been passed. In other proceedings, there are other proceedings also, my lord, pending before the parties. They're also, my lord, after, my lord, the order is passed, they come back and make this application. This is, my lord, on the conduct. They make an application saying, my lord, that please recall it. No, my lord. Sorry, my lord.
What about the method of the application?
Sorry, my lord,
Maintainability of the application.
Yes, my lord, maintainability. One, my lord, is on the question of jurisdiction. Whether, my lord, they will have to make out a ground under section, my lord, 263 of the Succession Act for them, my lord, to make this application, because it's not, my lord, an ordinary order. It's a no, not in that sense. My lord, they just stopped participating. It's not a question of ex parte. And, my lord, not only that, during the same period.
Where is the order? Where is the order?
Can you have a look at it?
And, my lord, just one more thing, my lord, my learned friend, my lord, should also explain, my lord, in the same period, my lord, he has been participating through his counsel in other proceedings, my lord, in Guwahati and Jorhat. That, my lord, we have a list of dates.
They have participated.
Yes, they participated, my lord, up to a certain date, my lord, up to 20th, my lord.
He had the evidence started.
20th.
But once the evidence started in the month of March, my husband, Lord, was diagnosed with cancer, and I've given evidence to that. Then, if your lordship wants, I'll show your lordship. We have evidence to show that he was a very. Then, my lord, what happens is, my husband undergoes surgery in US. That is, my lord, in June. And after that, my lord, post-operative care went on, my lord, in September.
How many days?
Lord, after about 4 or 5 days, Lord, after February 2025, 18th of February 2025, Lord, was a last day. Within time. And the judgment is passed, Lord, only on the ground that I have not had evidence. Can you have a look at it? Page 41. I'm sorry, 14. Have a look at it.
Yes, 14.
Yes. Have a look at the judgment. Starts off from 14. And below the reasoning, below your lordship will find my written statement, everything is recorded. Reasoning, below your lordship will find at page 18 bottom corner. And then 19, that's the only part. The lordship knows that the probate code is a code of functions. I find it. And now what happens is, if you start dealing with the properties, then it becomes instructions. And have a look at 268. My learned senior friend says 268 is lordship 11. Have a look at 268. The entire provisions of civil code, as far as applicable to the probate. So 266 is very different. That's in the point of very. So today, when we are allowed to deal with the properties, then my order line 230 application becomes instructions. Yes, sir. Because otherwise it becomes instructions. It's just activity, right? Whether appear, whether I have not appeared, it's a matter that order
this is an order passed by a learned judge. It's available. Now, order issued order was passed on September 9th. My learned friend has stopped the operation medical the moment in 2025. This note says that roster is learned judge is available. The application for issue. An order 9 June 30.
heard on merit.
Yes, let it be placed before the learned judge after vacation. It be heard on merit. Today, my lord, there is no scope for any interim order.
That is
My
stay
lord,
of the
Well,
order.
see-
Otherwise, in
Yes,
that
it becomes
application
infructuous.
my lord, Mr.
Well,
Banerjee wants to say something.
my lord, today, my lord, the executor, my lord, can only deal with the property, my lord, in terms of the order. That's, my lord, the order of probate. And, my lord, I don't know what property they're talking about because they have sold off a property, my lord, in the meantime, for which, my lord, for which a rule, my lord, a notice has been issued on contempt. My lord, while the matter has been pending. So, my lord, 3 points, my lord, we make. First, my lord, on the question of, my lord, that he has to, no, my lord, he has to make out a case so far as, my lord, the question of, my lord, stay of the order is concerned.
Lordship, kindly see the order where my learned friend client is facing an order of contempt.
medical ground, he did not appear.
No, my lord, that's not true. Correct. My lord, that's not correct. Mr. Sharma, just give the list.
Kindly see the bunch of order where
You
it is
mentioned in
appearing.
your applications regarding the grounds of
Kindly-
medical, you could
Yes,
not
yes,
appear.
Yes. My
Yes.
lord, may I just show that? My lord, may I just show that?
Kindly
Lord,
see
kindly
this
have a
bunch of order
Mr.
where
Sharma, may I just?
Not mentioned in paragraph.
Milord, kind I'll give your lordship the first Milord instance turns to Milord paragraph page 41. I'll give you lordship the evidence which is annexed.
Yes, we also want to look at the evidence. My lord, kindly look at the evidence.
Have a look
No,
at
no,
it.
in your petition, where
Yes,
is
yes.
the pleading?
My lord. Kindly
Where,
turns to,
in which paragraph you have mentioned?
I'll show you lordship. Para 21 onwards, everything is granted.
Yes. My lord, kindly come to my lord, paragraph 21. I also, my lord, want to show this. Absolutely, my lord, this frivolous case which my learned friend makes with so sorry, my lord, I'm making this submission.
Frivolous.
Yes, I'm saying that with some
Milord,
advice and some information.
with a person with cancer, Milord,
No,
it's-
sorry. I'm sorry. In other matters, my lord, my learned friend's client has been appearing.
that's a frivolous being made.
Yes.
you
My
will
lord,
show.
this is an excuse. I'm so sorry. This is an excuse which has been
Going
used.
through, Milord, cancer, going through operation, and my learned senior friend with a lot of
Yes.
See these orders,
My
my
lord,
lord.
Mr. Sharma will show. My lord, Mr. Sharma will show that my learned friend's client has been appearing in other
Kindly see the bunch
litigation.
of orders.
Same
Incorrect
period.
statements have
Same
been-
period.
Sir, एक तो दिए दी जज साहब
Mind your language, Mr. Sharma.
Kindly
Not from
see
the
the.
bar. Mind your language.
I'm sorry. Kindly see the bunch of orders, my lord, where my lord, we will show that the same client is appearing before other court.
Yes. Contesting.
Where the client has appeared personally.
Yes,
Let
the
them show
client
one
actually-
Here
order.
also, my lord, constituted attorney. My lord, may I just, my lord, kindly, my lord, just, my lord, two submission. I'm so sorry, my lord. I'm so sorry, my lord. My lord, I would generally not oppose, my lord, this kind of, my lord, order. But, my lord, here the situation is where, my lord, a applicant has come who's, my lord, not, unfortunately, my lord, not a bona fide applicant.
Lord,
My
I
lord,
am
Mr. Chatterjee, may I just make my submission? Mr. Chatterjee, I have the problem of appearing in VC. I'm so sorry today, my lord. First, my lord, that the petition, my lord, will also find has been, my lord, affirmed by a constituted attorney. My lord, kindly look at that. My lord, this petition has been affirmed by a constituted attorney. That's, my lord, one. It is not that, my lord, my learned friend's client has appeared physically anywhere. Secondly, my lord, during the same period, my learned friend's client, my lord, has been represented in other courts, my lord, relating to, my lord, the same property, where, my lord, the suits are in issue in both Jorhat and, my lord, Guwahati High Court. My lord, there is no explanation for that.
Considered at the time of
My
hearing.
lord, I am showing, my lord, the malafide, my lord, of this.
This cannot be taken into consideration. Those facts.
No, this is a malafide, my lord, application saying that I could not appear. My lord, that's what I'm on. My lord, kindly look at, my lord, the averment. And, my lord, according to the averment, my lord, only, my lord, 3 dates.
Has challenged. The petitioner has been challenged. Petitioner has Original side. Next. Appellate
The Lordship can find the schedule. My Lord, kindly come to page 21 of your Lordship. 21 of your Lordship's brief, my Lord. Page 21.
page 21 of your application.
Your Lordship's brief, my Lord. The
Yes.
civilization application, my Lord. The schedule A. My Lord, kindly look in, also parallelly look into the, my Lord, what I have handed over just now, my Lord. I have flagged the schedule portion.
Yes, 3 kattha of land.
My Lord. 16 by 1B Khanpur Road, jail number such and such, and the dark number is 50 and 164. I mean, all are same. My Lord. Kindly see the schedule what I have purchased. I have flagged the portion, my Lord. That is schedule B, schedule A.
Title suit was filed for cancellation of this deed.
My Lord, not this deed, my Lord. The deed by way of which the defendant purchased the suit property. Plenty filed for cancellation. Not this deed. I was not made party even. Well, I wanted to be a party in the proceeding. My application has been turned down.
You have purchased 40%
40%, undivided 40%.
and 60% is purchased by whom?
60% they already sold out to me prior to this transaction. The transaction with the plaintiff and
Now you became the 100%.
100% owner. I have not been made party in the proceeding.
You chop the copy to the other side.
But in the meantime, my Lord, 25th is the date, 24th is the date before the landed court below. They are proceeding again without me. My Lord, PH is the date. But kindly stay the suit. In the meantime, I will serve.
This revisional application filed under Article 227 of the Constitution of India, assailing
appear for the petition, my lord.
Lordship, I beg to appear on behalf of the respondent.
My there has
Opposite
been,
parties.
they have been reaction for service, my lord. Service has been effected. Affidavit service. My learned friend appears. My lord, what happens is, my lord, I file a section 17 application before the DRT. My lord, challenging the SARFAESI measures. Now, my lord, in the meantime, an order under section 14 of the SARFAESI Act was passed. My lord, I challenge that by way of an interlocutory application before the DRT. The DRT dismisses my application. Against that, my lord, I prefer an appeal before the DRAT. Now, my lord knows before the DRAT, my lord, if any appeal has to be preferred, my lord, there's a question of pre-deposit. So, my lord, I file an application for waiver. And I, my lord, also seek an interim relief that not to give effect to the order passed under section 14 by the CJM. I have twofold prayers, my lord. Now, my lord, by the impugned order, my lord, kindly takes the impugned order dated 7th of August 2025.
Page number?
My lord, this would be at the last page, my lord, of my lord's brief, probably, my lord. Volume 3. It's in 3 volumes, but it's voluminous.
Volume 3.
Volume 3, my lord, last page.
532, my.
Yes, order dated 7th August
Yes, my lord.
2025.
Yes, my lord. This is the order under challenge, my lord. Kindly allows me to place the order, my lord. Today is fixed for hearing on waiver application. Learned counsel for the respondent submits that he received the paper book yesterday evening. He could not file opposition. Learned counsel for the appellant would submit it is a peculiar case in which an application under section 14 of the SARFAESI Act 2002 was filed before the district magistrate. Writ petition filed by the respondents before the Honorable High Court at Calcutta, which was disposed of on 6/1/2025 with certain direction that the district magistrate should dispose of the application within 3 weeks. Learned counsel for the appellant further submits that the respondent moved another application under section 14 of the Act before the learned CJM without withdrawing the application pending before the learned district magistrate. Learned counsel for the appellant further submits that in the affidavit filed by the authorized officer dated 13/5/2025, it is recorded in point number 10 that the borrower, happens to be the petitioner, has repaid an amount of 6,45,06,461. This I'll show from the record that they have gone on affidavit saying this, that we have paid this amount.
What was the loan amount?
In the 13-2 notice, 13-2 notice, the claim was made for 3,30 lakhs. I'll show that for 13 notices. Kindly bears with me. Learned counsel for the appellant further submits that despite aforesaid discrepancies, respondents are trying to take physical possession of a secured asset. In such circumstances, let the matter be listed on 12/8. Opposition will be filed by within such date, copy by next date of hearing. What I'm aggrieved by is the non-consideration of my prayer for interim relief. Now, what has happened, the waiver application has been kept pending. And by interim application, interim relief, for stay of the order passed under section 14 has not been taken into account. That I believe there are two options open. Either we go back to the DRAT on 24th when it reopens and let my application be heard out. In the meantime, my lord will kindly protect me.
No. Why this court will protect you?
Kindly
You have to
put the
make
pre-deposit.
payment.
Yes, and I'll show.
As per the statutory.
I bow down, my lord.
If few lines of submission, member.
Let him submit first.
Twofold submissions, my lord. Now, I'll show it from.
What was the condition given to you for payment?
No condition given. Had the learned judge in the appellate tribunal asked me to pay something and
Well, there is a statutory
25%.
25%.
May I
You
put
must
it-
have deposit that one.
Kindly believe. The law is, 50% is usual, 25% is something which can be waived. 25% is something which can be waived. So minimum, I have to put in 25% of the 13-2 notice. The amount claimed under 13-2 notice is 3,30 lakhs. So I have to put in 25, minimum 25%. So that would be something down 77 lakhs and odd. I have records to show, and I'll show it, I'm carrying it, that after this notice of 13-2, the bank statement shows that I have made payments of 78 lakhs already. And there's a division bench judgment of the Bombay High Court passed by Justice Dipankar Datta, which says, while deciding the question of pre-deposit, either the amount in the 13-2 notice or the amount outstanding has to be taken into account. And if I am able to show,
What was the notice amount?
notice amount for kindly takes this 13 to notice at page 249. Kindly sees. This is 249 volume 2.
Two 49 P4.
Kindly sees the next page, page 250.
With 3
Paragraph
crore
8.
11 lakh 77,000.
So 3 crore 11 lakhs is supposed to be the 13 to notice, So I can maintain an appeal. I can maintain an appeal, if I can.
You have filed the appeal.
I filed the appeal. I have filed an application for waiver.
So waiver may be 25% or 50%.
No, 25% of 3 crore 11. 25%.
This is not the correct law, my lord. I will cite only one judgment that will clarify everything. A very
Let
recent.
him complete first, thereafter I will hear.
So 3 crore 11 lakhs is something,
So what is the 25%?
77 lakhs. But this amount, I have already paid subsequent to the 13th.
Prior to issuance of 13th.
No, after 13th I have paid,
My lord, kindly takes the impugned order once, my lord.
Kindly
Which
sees.
they are under challenge.
Kindly sees this, kindly sees.
Please wait. Let him complete. Thereafter, I will give you opportunity to
Kindly
hear
sees this, kindly sees this. The amount of money that I have paid according to the bank statement. Kindly sees this.
So that is prior to issuance
No,
of
after
13th.
13 to. After 13 to, But kindly sees, the 13 to notice is dated, 22nd September 2021. Got it, Now, kindly sees the amount that I've paid. Kindly sees the bunch of papers I've handed over. My lord sees, I have mentioned the 13 to notice as 22/9/2021. My lord, amount claimed in the notice is 3 crore 11 lakhs.
Yes.
Then, my lord, amount paid after 22/9/2021 is 78 lakhs and odd.
From 2021 to 2024, 78 crores.
Yes.
78 lakhs, crore 84 lakhs.
I have paid. So, the fact today remains is, I have paid more than the 25%. That is, liable to be paid for maintaining an appeal. Minimum condition. What today, I'm just, my simple prayer is, in view of this, when the admitted position is, I've already paid 25%, let my waiver application be heard out. And till that time, will kindly protect me.
You pay further 25%.
Further 25%, kindly cease.
And I will direct the
kindly, kindly visualize. Kindly seize the law. 18. Section 18, kindly seize.
May I just hand over? No.
What you are referring?
My lord, section 18, my lord, is the right to appeal against the order of the learned TRT. Section 18, my
lord. Yes.
Let's see. Any appeal, any person agreed by an order, as seen it, under section 17 may prefer an appeal along with such fee as may prescribe in the appellate tribunal within 30 days.
You have filed within time.
Within time. There's no qualms on that. Kindly sees what is this, the second proviso. No appeal shall be entertained unless the borrower has deposited with the appellate tribunal 50% of the amount debt due from him as claimed by the secured creditors and determined by the DRT, whichever is less. Then, provided also that the appellate tribunal may, for the reasons to be recorded in writing, reduce the amount to not less than 25% of debt referred to in second proviso. So, 50% is ordinary rule, 25% is something which can be waived. Now, the judge before the appellate tribunal ought to have considered this and passed an order. I sought for waiver. The learned judge in the court below could have said, no, your waiver is rejected, or you pay 25% or pay 35%, whatever be it. So this exercise was not undertaken. Okay. Number one, I've got two for submissions to kindly. Now, kindly sees this order which has been passed by the DRT is against an interlocutory order. Now, in a very recent judgment passed by the Supreme Court, kindly takes this judgment 2025 2025 SCC online SC 1234, where my lord, the division bench of Honorable Supreme Court has my lord struck posed a question as to what would be the interpretation of any order. My lord, kindly sees paragraph number 15.
Yes.
Which orders, in respect of which orders, my lord, pre-deposit has to be made. Kindly sees, my lord. We are of the view, of course, prima facie, that the expression any order should be given some meaningful interpretation. Should any and every order that may be passed by DRT, if sought to be challenged, made subject matter of pre-deposit. One can understand that if any final order is passed by the DRT, determining the liability of the borrower or any other liability of any person, and an appeal is preferred under Section 18 of the SARFAESI Act to the appellate tribunal, the provision of pre-deposit would come into play. However, what would be the position of an order like the present one, declining to impede the auction purchase in the present proceedings before the date is concerned? So, the Supreme Court now says that where the final order has been passed by the DRT, which determines the quantum of liability, only in respect of those orders, a pre-deposit is mandated.
No, for admitting your appeal, pre-deposit is required.
No, the Supreme Court says, the appeals can be from the final order and from the interlocutory order. In the final order, the DRT determines the total debt. In respect of those matters, pre-deposit is mandatory. So far as interlocutory orders are concerned, it is a discretion of the appellate tribunal. And
It is discretionary, not mandatory. It is
What I said, is discretion is 50% or 25%. Then there are two other issues. While deciding an application of waiver, the merits of an application has to be considered. What is the merit of the appeal? And then decide the quantum of pre-deposit. Even that has to be gone into. Kindly takes judgment of Dipankar Dr. Single bench. Kindly sees the question of waiver, would kindly sees this is 2012 volume 2 Maharashtra Law Journal 112. I beg to stand corrected. Justice Chandrachud, as his lordship then was. Kindly sees paragraph number 115. Page 115, paragraph number 6. 2012 volume 2 Maharashtra Law Journal page.
Yes.
Sees kindly sees page 115. I'll be reading in fact the 10th line from the top, which says that has to await the final determination of the appeal. Line, that has to await the final determination of the appeal.
Yes.
But it is a well-settled principle of law that even at that stage, the question as to whether a prima facie case has been made out has to be evaluated by the appellate tribunal. For the limited purpose of considering whether a dispensation should be granted, the appellate tribunal has necessarily to evaluate as to whether a prima facie case is made out, and the reasons which are to be formulated has to be confined only to determination. So, this is an exercise which the appellate tribunal has to consider and see whether I have a prima facie case or not. If the appellate tribunal finds I have a prima facie case, it can waive such pre-deposit. Now, sees the appellate tribunal order, nowhere has he taken this exercise. In fact, what I would be suggesting is twofold, If I can demonstrate before my lord that this, the order under section 14 of the SARFAESI Act passed by the CJM is faulted, even lords can exercise the discretion and pass an order of protection. Will kindly see what is the impugned order, Admittedly, why I say that this order passed by the CJM suffers from illegalities on two scores. One is, kindly sees there was an existing section 14 application pending before the DM, in respect the
direction was given by
the High Court had given direction.
Of that.
Without moving that, they prefer another application under section 14 because of CJM. Now, whether a second application of sections 14 before the CGM is maintainable or not, that's the question that has to be got into.
That will
No,
be
Mulad.
decided by that court.
Mulad,
Yes.
Perhaps my learned friend is not well informed about the proceeding going before the DRAT, or he is suppressing the fact, whatever it may be. I am not going into that. If my lord may take the impugned order, the last line says that opposition, if any, filed by 11/8, learned appellate tribunal granted us only 3 days time to file the objection. Let me know. So, my lord, primarily on two grounds, that during the pendency of the application, whether we have filed the application before CGM or not, we have appellate tribunal asked you to clarify, and there was 6 crore and 66 lakhs and odd which they are claiming.
That
we
was
have-
admitted amount.
No, my lord. I am coming to that, my lord. My lord, we have filed those objections.
No,
within
it
3
is
days,
recorded in point number 10 that the borrower has repaid the amount.
No, this is not
But page 325,
my
page
learned friend-
325.
this is my
Please,
learned
now
friend
you
keeps on
please
interrupting
take
my
your
lord.
seat. Please take your seat.
Now, my lord, this was the subject matter before the learned TRT also, where the proceeding was. My lord, this was a clerical mistake not in 9 points application. There is a procedural application which requires 30-point objection affidavit. That was a clerical mistake, my lord. That was agitated before the tribunal, relied on several judgments.
No,
passed by our-
whether they have paid that.
No.
amount or not.
As on
You are
date, we have-
disputing.
my lord, as on date, we have filed our
No,
objection.
they have given the dates.
No, my lord. We have filed the current statement of accounts. Actually, what happens, my lord? Once the
You
account.
file your objection.
No, my lord.
File your
In the
objection.
meantime, Mulad, can you protect me, Mulad?
No, my lord, kindly
In
allow
the
me 2
meantime,
minutes. I
kindly
will not
protect
take
me.
more than 2 minutes. Kindly allow me 2 minutes. I will clarify everything. 2 minutes, not more than that. My lord, 4 crore and 4 crore 70 lakhs and odd is due as on date. Number one.
No, according to your
No, this is my lord.
notice
What
under
has- we
section
have-
13,
My lord, we have filed the
3
current.
crores 11 lakhs is due.
No, my lord. We have filed the statement along with the objection before the appellate tribunal. We have filed it, showing the current statement of accounts and the liability. Number one. Number two, my lord,
So according to you, what was the amount to
4
pay?
crore 80 lakhs and odd is due as on date.
Exact amount is this.
So 24%
My lord,
of
exact
that
amount-
amount you pay.
Exact amount is.
Mulad,
And now, my lord,
kindly bear with me.
You pay 25%.
Mulad, of 4 crores, I've
my
already
lord,
paid 78, Mulad.
my lord,
I've
kindly
already
consider.
paid
Rest you pay.
My lord,
You rest you
I
pay.
will. But kindly, Mulad, bear with me.
Supreme Court recent judgment, my lord. Kindly consider this.
Okay, I have heard already.
Mulad,
My
kindly
lord,
bear
if,
with me,
if
Mulad.
my lord considers this, they says that borrower is not at
Revisional application
May I
has
indicate,
been
Mulad,
filed
kindly
by
bear
the.
with me for 1 minute, Mulad. 1 minute. Kindly takes the page 325 for once. 325. Once for my satisfaction, Mulad.
325.
325. This is the affidavit filed by them, Mulad. Page 325, Mulad, volume 3.
325, volume 3, no?
Yes.
Mulad, kindly see paragraph number, point number 10. It is their application, Mulad, their affidavit. Kindly see 10.
The law allows.
Total amount repaid by borrower 6 crore 45 lakhs 6,461. It is their document, Mulad.
My lord, this was the clerical mistake which I was referring to. This was considered by the TRT, and upon hearing the matter on merit at length, my lord, the order was passed.
And may I
And
put
this
this way,
section
Mulad,
14
may I
of
put
the-
this way?
My lord, they are
Mulad,
trying.
Can you show me that document that 4 crores is due?
Let them show.
My lord, we have filed along with our objection, my lord.
Huh?
We have along with the
In
complaint.
the meantime, there shall be a stay.
No, my lord, please don't.
Where
My
do
lord.
I go, Mulad?
My lord, this is the forum. My lord, kindly consider.
How court can rely upon your submission
My lord-
without any document?
My lord,
Your document itself shows.
no, my lord. That is only the part. That is, my lord, kindly take.
What is the dues now? Tell me.
4 crore 75 lakhs.
Where is that?
My lord,
Have you informed them?
my lord, yes, that is.
Where is it?
My lord, I don't have the copies of the statement, but they have been served, my lord. On
Mulad,
affidavit, I can say they have been
Mulad, may I
served.
put it this way? Mulad, may I put it
Again,
this
my
way?
lord,
You
my
pay
management continues like this, my
25%
lord,
of 4 crore.
Mulad,
Would you like to
25
pay?
25 lakhs.
Mulad, 4 crore of 25%.
Would you like to pay 25% remaining
My lord, kindly consider
64,000?
it. My lord, I will file the statement, my lord.
May I make a submission, Mulad? 25% of 4 crores is 1 crore, Mulad. Right, Mulad? I have paid 78.
Rest amount you pay.
That is 22 I'll pay.
No, my lord. This cannot be, my lord. Kindly
It's
consider
neither
that.
this way nor that way, Mulad.
You have to follow the principles of law. My lord, consider the 23 judgment Supreme Court has said, my lord. Kindly consider this.
Which paragraph?
Paragraph 13 onwards, my lord. Kindly see, my lord.
Which portion? Relevant
My lord, I'm
portion?
just coming. Kindly allows me a moment, my lord. My lord, kindly takes paragraph 13. Siddha Nilkant, 23 Supreme Court.
But Siddha Nilkant Mullah is on the proposition that the purchaser has paid the money.
No,
Yes,
no.
Mullah, kindly cease.
My lord, kindly takes paragraph 18, my lord. The most relevant person.
I think
Paragraph 18.
item number 14. Oh,
Paragraph 18, internal page is 13.
yes.
After considering the decision of this case, in detail, section 18, after considering decision of this court in case of Narayan Chandra Ghosh, my lord, this judgment assails from our High Court, my lord, in UCO Bank 2011 4, it was observed and held that provisions of section 18, more particularly the second and third provision thereto are mandatory in nature, and that the debt recovery appellate tribunal have no power to grant full waiver. Section 18(1) clearly, my lord, I am not quoting the section 18, my lord. Now, my lord, kindly takes the last portion. Debt due from him to be interpreted consistent with the object and purpose sought to be achieved by the SURFACE Act. Unless the debt due is secured, my lord, the borrower cannot be allowed the luxury of litigation. If this permitted, the secure creditors would be engaged in continuous and futile litigation, my lord. This is what happening. Our money
No,
is
you
due.
come to the last four lines. At the best, the appellate tribunal could have, after recording the reasons, reduced the amount of deposit
25%.
of 50% to an amount less than 25%.
But what? Up till interest, my lord. Kindly consider this.
But where is the statement?
My lord, we have filed this statement. Kindly fix it.
Then, Mullah, then in that
Kindly allow
event,
me,
Mullah,
sir, please.
let me go back to the
Okay.
TR 24.
Okay, I have heard.
My lord, kindly pass it over at all. We will file a statement right now. And I'm not there suppressing the
Let
fact.
him submit 25%. Thereafter, matter will be heard.
Mullah, I have paid 78.
25% of the due, my lord, as per this judgment.
Mullah,
25% of the debt.
No, Mullah, that is not
I
the
have
law.
agreed to that, man.
That is not the law, Mullah.
That is the law, my lord.
Mullah, kindly cease. Mullah, kindly cease.
The
Kindly
petitioner
cease
filed
that,
an
Mullah, just stop.
application under
Mullah, kindly cease that.
47 of the
Mullah,
Constitution.
Mullah, grateful.
Item number 3.
Item number 3, my lord, I'm appearing for the petitioner.
No, no. Acha. Let the disposition. Yes,
My lord, in this matter, my lord, I am seeking custody of my son, my lord. Unfortunately, my lord, kindly seize the impugned order.
বন্ধ করে দেবো।
My lord,
Live streaming close. Yes,
my lord, kindly seize the impugned order, my lord. My wife had filed no objection to my application for custody, and instead, only relying on a firishti filed by my wife, I have been deprived of even visitation for my